And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right.
Yeah, it's rewind time.
When you pled guilty on December 28th, 2022, was that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea, though, if I'm not mistaken.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney that, like, I didn't want the probation. I just take the straight prison sentence.
Okay. Yes, sir. All right. Outside the presence of the jury. Okay. Yes? Yes. Okay. I'm going to excuse y'all to the jury room.
He mentioned the jury. He mentioned the plea deal again, or mentioned the. I don't know. This is getting a little bit confusing. Adrian Love, why are your people always fighting you? Adrian, what is the deal? What's going on? Why Adrian people not supporting Adrian's mission? I heard that too. I heard my lawyer awared me.
Yes.
Yeah, she just keep.
To do what? Sure.
The state has horrible witnesses. Let's just tell the truth. The state just has bad witnesses.
Yes, sir.
Thank you, Your Honor.
Get your mic.
Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature, because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alfred, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alfred plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alfred, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alfred plea in this 2015 case. So Mr. Wright wants to share something. Yes, sir.
Waiting for the appropriate time that I was going to point out that it was in fact an Alfred plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that, yeah,
It was something other than Alfred. So
maybe don't wait so long next time. But, I mean, I'm definitely going to, Ms. Love, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the assertion that no inconsistent statement was made
Mhm.
in the factual acknowledgments.
Okay, no, see, that's the deal with an Alfred plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But you're not acknowledging on your own, yes, these are true.
Your Honor, when
Yes, ma'am.
I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought you meant.
Within 444Y, we referenced this particular
All right, let's,
section.
maybe if you can point me specifically, let me pull that one up.
Page
Which number? Go ahead.
number 3 on page 3 of 7, under defendant's factual,
Mhm.
I'm sorry, not number 3, number 4, on defendant's factual acknowledgments on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction would be true for.
And
But the factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
Your Honor, in number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5 above.
Okay.
And so if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 138994, but given the factual acknowledgments that were made as it relates to 22 SC 183572, and the fact that this witness did not assert, even though the plea was given in his best interest, he was allowed an opportunity to say what he said here, and he did not say it.
No.
Uh-oh.
When a defendant
Was
has
that
an
a no?
attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, judge, here's what Alfred means. So
Understood.
no. Are you going to tender for admission any part of 444Y
Yes, the state intended to tender 444Y.
in its entirety?
Yes,
Mm.
I did.
Any objection to that being tendered or admitted in its entirety?
And if there is an objection to it,
All
then
right,
we would just.
let's find that out.
Okay.
Come on, let me hear. Come on, Matthews. Adams.
Yes, I objected at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. You know, I'm trying to follow this factual basis, and I realize I asked Ms. Renard, Renard, for this, and we're in a different case.
Yeah, we are. So, I mean, we've been talking about these 2015 crimes, and we've been talking about, you know, what's been going on in this 22 indictment. So, I mean, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because I mean, I noticed this morning that this was an Alfred plea.
Right.
And I would have had issues with, when you started reading out the factual basis, I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015 case, we believe that it would be appropriate for, is an appropriate matter for cross-examination, and it appropriately falls under the portion of the court's instruction where it tells the jury that the conviction itself is not to be considered as evidence. And to the extent that Mr. Sledge is asserting that he didn't do it, that he dropped someone off, that is what he asserted, by the way. He said that he was not present, he dropped him off, and it was only one house.
Well, we all know how party to a crime works. So, I mean, yeah, he said, I didn't shoot, but he
said
did
he
admit
didn't.
to being the driver.
And so, to the extent that he said that the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on, he made a very blatant, inconsistent statement that YSL is not a gang. And in this factual acknowledgement
All
section,
right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
no, in the 22 SC
Okay,
183.
okay, yeah, no, I mean, all of that is inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, you know, part of the 22 factual acknowledgements. So those factual acknowledgements in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not apply.
Does not
to-
apply. And that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one,
Okay.
this
This is
free.
I
amazing.
see what, yes,
Okay.
yes.
All right. If anybody wants to suggest specific language, I'm willing to.
How about the
listen.
language,
Otherwise, I'm just
mistrial
gonna kinda
language?
And
Give it my best shot.
I would
and,
like.
Your Honor, may I say one more thing?
Yeah.
Because number one, the court has
Wow.
previously instructed the jury that questions and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest,
Mhm.
and given that he can also be cross-examined as to whether or not he can, he was asserting these things,
Mhm.
we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness rather
Mhm.
is required.
Okay.
I just respectfully don't think that goes far enough. You have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alfred. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total confrontation clause violation. It's the second time.
All right. And that's Zachary and,
Well, Mr. Zachary, I anticipate may testify.
right.
I don't know.
Let
if
him
he hasn't
talk.
yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying.
Let him
Then-
talk.
Just for you to know, you were not here, but the predecessor judge permitted over objection the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by
Avoid-
the Supreme
Oh,
Court of
right.
Georgia.
Yeah, I remember you.
So, and
Didn't he
then
enter another one after the fact though anyway?
5 years later, Alfred plea and said I'm
Okay.
specifically innocent.
Yep.
I mean, it was a farce.
Right.
And
Okay.
then the predecessor judge wouldn't even let me examine the witness. And Miss Love said that the witness I could call in my case in chief on direct. So
Predecessor
the
judge.
reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness
can't stand that.
testifying
I
about
can't stand her.
Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected
No.
him to be talking about.
Right. Okay. But nonetheless, we have that now before the jury.
We would
So-
ask that the court tell the jury to strike, disregard, put out of their mind anything about the
Thank you, moderators.
Mr. Garlington pleading guilty.
I'm just to say anyone other than the witness on the stand.
Okay.
Just to say
There
something.
we go. One in chat.
All right.
Judge, I fully adopt on behalf of Mr. Nichols, and I know I don't need to under the rule we're operating under, the motion for mistrial. I understand your ruling. I understand you're going to give an instruction, but I ask that as part of that instruction for an admonishment under 17-875, and I think that admonishment is mandatory, where counsel makes statements of prejudicial matters which are not in evidence. And I believe that this applies to this particular instance under these particular circumstances. So I'd asked the court to admonish counsel. Yes, in front of the jury, obviously, as part of the instruction.
All right. Give me a second to get signed into Lexis and take a look exactly at what the statute says.
Okay,
Give
well,
me that site again. 1775. I left out a number.
I don't think they'd be caring. Oh, I didn't even notice that. Hilton's gone. Sorry, wait, where's that? Hilton's gone. I
Do you
didn't
have
realize
any
that.
suggested language? I'm sure you do. That would be appropriate for the court to give at us as an admonishment.
I haven't, we can come up with something.
All
pretty
right, well,
quickly.
let's endeavor to do that right now.
We can come up with something. That's hilarious. That's got to be the funniest thing. What in the world? This is such a kangaroo show, man. Yeah, I have no idea what they're doing.
Permit the state to make a
You,
response.
you may
No, be quiet. Be quiet. We tired of hearing you talk.
go ahead.
Now, okay. Your Honor, given that 17875 refers to statements of prejudicial matters, which are not in evidence, and the factual basis given or read by the prosecutor in the plea in the 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183572, it contains, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demekion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence, and that they committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, and that he admitted and was convicted of aggravated assault, participation in criminal street gang activity, and among other charges for his participation in the drive-by shooting referenced in sections 3, 4, and 5. And given that this evidence will be properly before the jury, our position is that these statements, the questions that I asked, which contains the factual basis, the assertion about the factual basis in the 15 SC case, would not be a prejudicial matter. Though the factual basis is not in evidence, the fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that
Okay.
that should go, but that
So-
was not something that I
No, I know.
Lisa
I don't think that
Babbage.
you intended to elicit
person.
that. But yes, I'm going to give a rebuke.
A rebuke is needed. Let's go.
That's just what it is sometimes.
Type
to be a
rebuke in the
prosecutor
chat.
in
Rebuke.
case.
What? A rebuke? Let's go. We need some rebuking up in here.
Gotta have a tough skin.
About time.
Suggested language, Mr. Harvey or others.
Need for some smarter colleagues to give me some suggestions, which is everybody in these three tables.
And Your Honor, I'm still reading under the annotations of that particular statute
Yeah,
regarding
but you know,
the
we
rebuke
also
language.
presented this, by the way, as a guilty plea, not as an Alfred plea. And we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17-875. And I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard. And the state should not do that again.
Your Honor, what the annotations say is what the law forbids is the introduction into a case by way of argument of facts, not only not in the record, but that are calculated to prejudice the accused. And
All right, Ms. Glove, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing. to the nth degree. I've already said I'm giving it. So, I mean, I can grant a mistrial if you prefer.
Oh, no. I do not
Okay,
want a
then
mistrial.
maybe stop arguing at this point.
Yes, Your Honor.
Okay.
Wow. Keep your powder dry and shut up. Wow. Okay. I got you, Judge Whitaker.
Now, in terms of her having presented it as a guilty plea, an Alfred plea is still a guilty plea, so I don't find there to be anything wrong with her having references
Okay,
in a
yeah, I
guilty
guess so.
plea. But, you know, we already talked about the whole factual basis thing, so I won't rehash
Right.
that. But
2 months late, but
Okay.
okay. I'm kind of wondering, like, I want Love to get in her face and argue like she did with Glanville. That thing was hilarious. Love needs to have tough skin. Why? You ain't doing nothing tough, Whitaker. You ain't doing nothing tough. This is your first time doing anything that has us thinking that rhymes with tough, okay? You have not done enough, all right? So just give it a rest. You keep your powder dry. Shout out to Alan all the way over in Germany. My man.
all right, and after I give the instructions, I am going to
No,
ask
right,
y'all,
hand
I
clapping.
understand that you, the mistrial motions are preserved, but I am going to ask, since I haven't read out yet what I'm going to say, if y'all have any suggestions that you think would further elucidate, clarify, cure anything. I'm going to ask you for that. And if you have them, I would like for you to let me know that, and we can come up to the bench and consider any other further curative instructions. Okay.
Meaningful.
All right. All right. Let's get the jury back out. And
It
I mean,
needs-
I don't know that we need the witness in here for that, but
It needs to
will
be
the court
tough.
prior to-
go ahead.
Will the court prior to bringing in the jury, would the court be willing to read the,
What I'm going to
Rebuke.
say, well, I don't know what I'm, oh, the rebuke. I mean, it's probably going to be something to the effect of, after I explain to them what they're not to consider. I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr. Harvey wants more. What else?
Right. Come on,
I'll
Harvey.
consider it.
You should be banned from asking any more questions ever for the rest of the.
Well,
For the rest of my life.
reasonably speaking, though.
Harvey.
That may be going a little bit too far. But that's already been asked for, by the way.
Good point.
And that the court, in giving these instructions, intends to rebuke the state for asking those, for eliciting that improper testimony.
Come on.
so Your Honor, it wasn't improper testimony.
Let's
It was
go.
the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court just, if the court is going to read, that the court reads only what the court initially said.
This is that child that just won't stop talking. You say, I'm gonna take your phone from you for a day. And they just keep talking. You say, I'm gonna take it from you.
I will say you should not have
To
put
the
that
weekend.
factual rendition before the jury as anything this witness admitted to. Mm-hmm. I'm listening.
At the time he pled guilty
Okay.
in 2017, because
I understand.
This that stuff. This is how I used to get
Give me just a second.
used to get grounded for a month. Because I
Sorry.
would keep talking to my dad. Just take it and be quiet. If he said you get grounded for a week, then just take it and be
Yes.
quiet.
Let me request that the court.
Come on, Adams.
Consider including in its admonition the following language, if the court deems it to be appropriate. Somewhere in there, the presentation of that evidence that I've described was improper and was not in keeping with the law and the prosecutor's ethical obligations. Accordingly, the state is admonished for their behavior and is instructed to refrain from asking or presenting any improper questions or evidence moving forward.
All right. I'll do a little bit of it, but not all of it. What was that last sentence?
I like the first sentence.
I'm sure you do. Instructed to refrain from what?
Refrain from asking any improper questions or presenting improper evidence.
All right. Well, they're not presenting evidence, so.
And
All
must,
right.
and should conduct themselves within their ethical obligations
All
and
right.
legality.
Thank you. I'm not going to do that.
Got some more?
Got some more? All right. I think this is going to be enough. All right. Let's get the jury out.
We should start a poll to see how long it'll take for them to get in trouble again. But like I said, like this, Adrian Love must have
I mean, you
stayed
don't want the
grounded.
witness in here for this? Okay, let me ask you
She
a
must have
question.
stayed
Have you,
grounded when she was a child.
or somebody instructed, maybe even Mr. Wright, the witness to
Mr. Wright.
not talk about anybody else's plea to anything? Can Mr. Wright just do that? All right, let's get the jury out.
Okay, it's 3:45, basically 3:50. Please forgive me, 3:50. So if they get done at 5, we got about an hour and 10 minutes, give or take.
Be in here? Okay,
Your Honor, we do
right,
request
all
that the
right.
witness is present.
okay.
Come on, Ms.
Somebody let
Westmoreland.
them know that. You can hurry. I mean, I've already said for the jury to come in, so.
She was begging to keep that hidden. She don't want people to know she got in trouble. She does not want to. But I think more people, the more corrective action is taken, the better they'll become, or at least they should. I think I became a better person from getting a good old spanking every now and then. She needs to be disciplined. And this poor guy, Atkins, he just like, look, I'm just here so I don't get sued. I'm just here so I don't get fined. I mean, this is hilarious in a bad way, wandering sub. It's funny in a bad way. Look, just leave me alone. I'm really trying to get over here to this job interview today. No, really, I'm serious. I've already sent them my resume. They've already sent me a job offer. I've had enough of this. I'm trying not to tell you. I don't want anybody to read my lips.
All right. Thank you.
I mean, really.
All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alfred plea. It's just named after a case called Alfred. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying, I think it's in my best interest to go ahead and resolve it that way. So everything that you heard is, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alfred plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to, he had no requirement to, he had no responsibility to, okay? So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial, When it's an Alfred plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.